All right, so we'll go ahead and get started. Thank you everyone for bearing with us for a couple of minutes. I know we are starting a couple of minutes late. Technical difficulties are now a fact of the public-facing world these days. Thank you all so much for coming. My name is Ben Juvelier. I'm the Programs Officer at the American Society of International Law. For those of you who are not familiar with the Society, we are a 114-year-old professional membership association devoted to the promotion of international law and justice both in the United States and abroad. It is wonderful to see so many people interested in the virtual content from the Society. This webinar is continuing the series of virtual events that we will be hosting online over the next couple of months. For more information, you can always feel free to check back regularly on our website at acil.org/events. We have all of our upcoming content listed there, both virtual content and in-person content, once we are allowed to move back to holding in-person events. Our spring series of virtual content is going to culminate in the first ever virtual annual meeting. This is the rescheduled form of our annual conference that will take place on Thursday, June 25th and Friday, June 26th. This year's annual meeting will still feature over 50 hours of substantive content, over 150 speakers, and plenty of new features designed to take advantage of this virtual format. For more information about that, including for information on registration and programmatic content, please visit acil.org/annual meeting. Lastly, I'd like to say a few things about the Zoom webinar format itself. Please note we have disabled the audience chat, camera, and microphone participation. This is just to make things a little bit cleaner and easier for everyone to communicate with each other. We will obviously still have a live and interactive question and answer period. You can feel free to click on the button entitled Q&A at the bottom of your screen and then type in a question. This will go directly to the panelists and to myself. And then we will be sprinkling these questions in throughout the course of the panel. You can do this at any time during the panel, and then we will also have some dedicated Q&A time at the end. Now, I've kept you all from the content long enough. It is my pleasure to turn things over to our moderator, Darren Johnson, who will introduce himself and the rest of the speakers, and we can kick things off. Thank you all for coming.
Thank you, Ben. Good morning. My name is Darren Johnson. I'm a professor of law at Howard University School of Law. I specialize in international law and national security law, and it is my distinct honor to moderate today's panel. As many watching this webinar understand, the protection of cultural heritage during times of conflict has been a priority for the international community for over a century. Provisions in the Civil War Liber Code and in the Hague Conventions and regulations of the late 19th and early 20th century laid the groundwork for future international treaties. The international effort to protect cultural heritage has been popularized in such films as Monuments Men. This international effort is more important now than ever, given the destruction of cultural property that we have seen in recent conflicts, including in 2001, when the Taliban demolished 2 giant Buddhas at Bamiyan carved from a cliff in central Afghanistan 1,400 years ago and considered to be one of the world's artistic treasures. Or in 2013, when the minaret of the Umayyad Mosque, one of Syria's most famous mosques and a UNESCO World Heritage Site, was destroyed between clashes in the city of Aleppo between the Syrian government and rebel groups. Or in 2015, when ISIS captured Palmyra, Syria, and quickly started targeting cultural sites. In a matter of months, ISIS plundered and destroyed ancient artifacts, including the 1,800-year-old Arch of Triumph and the nearly 2,000-year-old Temple of Bal-Shamin. Our panel today will discuss the mechanisms that exist under international law to prevent these atrocities, as well as the measures that are in place to bring accountability to perpetrators. After I introduce our panelists, we will move directly into our discussion, and we will reserve some time at the end of our discussion for our panelists to respond to questions from the webinar viewers. So we are very fortunate to have a very distinguished group of panelists with us today. It's my distinct honor to introduce them to you. Our first panelist is Dick Jackson, a retired Army colonel and attorney with over 40 years of government legal experience. Dick Jackson served as the civilian special assistant to the Judge Advocate General for Law of War Matters from 2005 to 2016. He is the outgoing vice president of the U.S. Committee of the Blue Shield, and he represented the U.S. at the first several states party meetings for the 1954 Hague Cultural Property Convention at UNESCO. Roger O'Keefe is professor of international law at University of Bocconi in Milan and honorary professor of law at University College London. His many publications include the book titled The Protection of Cultural Property in Armed Conflict. He was academic coordinator of the drafting team responsible for Protection of Cultural Property Military Manual, a joint initiative of UNESCO and the International Institute for Humanitarian Law. And he provided advice to the UK government during the passage of the Cultural Property Armed Conflicts Act of 2017. Maria van Wagenberg is an attorney advisor in the Chief Counsel's Office for Foreign Assets Control, where she advises on legal issues related to the administration and enforcement of US economic sanctions. She graduated from Harvard Law School in 2011 and practiced international trade law at a DC law firm for 5 years before joining the Treasury Department. Corey Wegener is director of the Smithsonian Cultural Rescue Initiative and retired Army Reserve Civil Affairs Arts, Monuments, and Archives officer. She is also the founding past president of the U.S. Committee of the Blue Shield, a non-governmental organization dedicated to supporting implementation of the 1954 Hague Convention. So as a preliminary matter, I'd like to turn to Roger to help set the stage for our discussion. Roger, from your perspective, have cultural protection treaties accomplished their objective of shaping the behavior of states during conflict?
Darren, well, before answering your question head on, I think we need to ask ourselves what are the factors we take into account in assessing whether they've been successful or whether they've failed. And I'm going to give you what I guess in some ways are caveats both as to apparent failures and as to apparent successes. And I think each of them provide a point of entry for the other speakers today. The first thing to say is that law as such can only ever do so much. And international law, and in particular the laws of war, I think this goes doubly for them. We don't say that the law of murder has failed just because Jeffrey Dahmer existed or Ted Bundy. There are always going to be people who set out deliberately to break the law or for whom the law is meaningless. And so in a way, we can't measure the success or failure by reference to the Nazis, Al-Qaeda, ISIS, and so on and so forth. We need to take that into account, but the fact that these people do stuff does not necessarily mean failure. The other thing to say, and I'm going to come back to this point afterwards, is that many of the positive obligations here require capacity to fulfill them. Human resources, institutional resources, financial resources. Now, these aren't all the obligations, but many of them, with all the best will in the world, cannot be adequately fulfilled unless there is the wherewithal to do it. And so capacity is a key issue here. The second thing to say is that the law does not prohibit completely the destruction of cultural property in armed conflict. It completely prohibits the theft and the other forms of misappropriation, but there are instances in which a force may attack cultural property, in particular when it's being used to make a contribution to military action, or when collateral damage to cultural property, cultural heritage is lawful. So just because these things are destroyed does not necessarily mean it's a failure of the law. Thirdly, many of the rules are actually about getting things out of harm's way. They're also about training. They're about providing specialist personnel and taking other precautions. And these are the sorts of proactive, boring, unsexy measures, which often go under the radar and we don't notice the fact that they're having an effect. The final thing about potential failures is to say that these rules are just part of the story. We need equally to take away the capacity of certain actors, and this will happen not through these rules, but through financial sanctions, through measures in relation to illicit trade and the art market, and so on. The final thing, before answering your question, is even success isn't necessarily down to the conventions, because safeguarding cultural property in armed conflict makes good military sense from a point of view of what they call strategic communications. It's good on the home front, and it's good in the countries in which you're fighting. And also, of course, many people just, think it's a great idea. You don't need the law for that. That said, the law plays a role. Coming to your question, I would say that these rules have accomplished far more in shaping the behavior of states and non-state armed groups than the advertisement like Hazel would suggest. Yes, of course, look, there were the Nazis, there was ISIS and so on. There were the Bosnian Serbs who deliberately set out to destroy things. Equally today, there's some states involved in the conflict in Yemen that don't take these things seriously enough. Equally, mistakes have been made, but as is often the case, these mistakes and these tragedies have actually spurred action. And what I am astonished by is the mainstreaming of these rules now. Militaries all over the world are taking these things extremely seriously in targeting, in developing precautions in targeting and protocols. The United Nations Security Council has adopted a range of resolutions in this regard. But it's not just states. A fantastic piece of research by a group called Geneva Call shows that non-state armed groups, by and large, don't set out to destroy cultural property. Most of them are like the Kurds or groups in the Philippines and so on, who are actually fighting for cultural rights and cultural protection. Their main challenge, and the biggest challenge for everyone, is capacity, okay? The technology, the know-how, and simply the human power, sometimes boots on the ground protecting sites, to fight against these things. The challenge posed by the dark net and so on in illicit trafficking. So the answer to the question is the conventions have done a lot more than people think. They're doing more and more, but yes, of course, as with every body of law, we need to work on implementation, and we need to work on other areas which help buttress and support the legal efforts represented by these norms.
Thank you, Roger. I'd like to take a brief moment to introduce our final panelist who has joined us. Ari Vallejo is a senior sanctions policy advisor with the Office of Foreign Assets Control. As part of her policy portfolio, she mainly focuses on sanctions-related issues pertaining to the Western Hemisphere, as well as global human rights and corruption issues. Welcome, Ari. I thank you very much for that framing of the discussion, Roger, and for your observations of both the factors that must be considered when assessing how best to protect cultural property, as well as the role that international law has played in shaping both the behavior of states, international institutions, and non-state armed groups. So I'd actually like to turn to the behavior of states. And so I have a question for Dick. So Dick, what has the US military done to fulfill its obligation under cultural heritage protection conventions? And as a second question, what have been the most significant challenges in shaping the behavior of other military forces that may not prioritize cultural protection in the same way that the United States does?
Well, thanks, Darren, and thanks, Roger, for that great introduction to the topic. Thanks to ASIL, too, for the invitation. I'm a longstanding member of ASIL and the past chair of the Liber Society. So I really appreciate the ASIL's efforts to disseminate information on this important area of the law. The answer to your first question with regard to what the U.S. has done to implement and first to ratify the Hague Cultural Property Convention, it really was spurred by, like many forward progress in areas of implementation of the law, it was really spurred by some mistakes that we made in Iraq and Afghanistan in the early 2000s. The U.S. eventually ratified the 1954 Hague Convention in 2009, and between 2003 and 2015, I would say, we increased our efforts to implement provisions of the 1954 Hague Convention. The U.S. and coalition forces learned principally from several mistakes made in Iraq. Initially, targeting in both Iraq and Afghanistan was very good and avoided cultural heritage. But since those initial fights in Iraq and Afghanistan, we've learned a whole lot about the existing cultural heritage in both of those locations. And much of that has been learned from relationships established with civil society, like the U.S. Committee of the Blue Shield, headed by Corey, as you'll hear in a few minutes. So the information really has to come from civil society so that the military knows what it is that needs to be protected under the provisions of the convention and its protocols. The second area where we didn't do as well, and that also spurred some efforts, is in the area of looting and protecting cultural heritage during and after the conflict itself, and in the fourth phase of the conflict, during occupation phase or stability operations. The U.S., as Corey can demonstrate very well, the U.S. didn't do so well in protecting certain cultural heritage, including the Iraqi Museum, from looting. Often although we protect it from looting by our forces, we did not protect it from looting by the Iraqis themselves. And so that was a lesson learned that we have improved on since, with policies like the DoD Law of War Manual that are intended to prevent looting from all actors in the context of armed conflict. But also, we have increased our advisory services to host nation authorities that are responsible for securing and mitigating damages from armed conflict to cultural heritage. Finally, the gaps in the specialists that were required and are required by Article 7 of the 1954 Hague Convention were identified and have been worked on in the U.S. and in other partner nations, including most recently the U.K., by accession, training, and filling billets for the specialists within the military that are designed not only to protect cultural heritage, but also to assist host nation authorities in protecting that cultural heritage during and after the conflict. And I think Corey can give us a lot more insight into that work, as that's been the principal focus of her efforts in the past.
Thank you very much, Dick. And so that's a perfect pivot to Corey, right? So Corey, many people have seen the film Monuments Men, which has told the story of World War II officers whose job was to protect and preserve cultural heritage. Before we talk about your work with Blue Shield, I'm curious whether there are any similar efforts underway today to train monuments men and women to protect and recover cultural heritage.
Yeah, thanks, Darren. And thanks to ASIL for having this session today. So yeah, Dick Jackson really kind of kicked it off. I think people might be surprised to know that actually the monuments men, people, officers, never actually went away, really. I mean, there was a time when after World War II, they continued on, several of them continued on working at the collecting points to return looted cultural property back to the countries of origin until the early 1950s, actually. But the Civil Affairs Division in the US Army, where the Monuments, Fine Arts, and Archives teams were assigned, actually has maintained its presence within the US Army and has always had what we call civil sector experts within civil affairs. The headquarters for civil affairs is the US Army Civil Affairs and Psychological Operations Command at Fort Bragg. And as Dick mentioned, in recent years, there's been a renewed effort to really professionalize the accession and retention and even recruiting of people from the civilian sector who might not otherwise already be in the military, and to do a direct commissioning program. And so that's pretty exciting. It's not unlike World War II, where they tried to find people who are working in the field of cultural heritage. And it's not just for culture, it's a number of types of expertise that you need when you're going to, for instance, take over a country and run the governance of that country for a time as a military government. So as Dick mentioned, the UK also have renewed their efforts, and they have a monuments officer group, and they had a training last year that several of our US Army folks attended. We had 3 US officers in that. And this year, but for the COVID-19 epidemic, we would have had a training in March at the Smithsonian for a group of existing and potential monuments officers at the Smithsonian in March, and we've rescheduled that for either later this year or early 2021. But it is exciting because these folks have a lot of expertise. We have archaeologists, we have library studies professionals, we have museum professionals, all coming together in this group to cross-train and to also learn more about the international legal conventions, more about the Hague Convention, and to also train their other civil affairs brethren and the larger force about the Hague Convention and our responsibilities when we go to war.
Wonderful. So in addition to this great work being done within military forces to train up this cadre of monuments officers, what role can NGOs, right, like Blue Shield and the ICRC and their national committees play in helping to protect cultural heritage? And given your role with Blue Shield, it'll be interesting to hear your experiences in this capacity.
Well, I think that the first goal of the International Blue Shield movement is to try to ensure that countries ratify the convention. And I have to say that I was a little surprised going into Iraq in 2003 to learn that the United States hadn't actually ratified the Hague Convention, even though we followed it as customary international law. And so when I got back from Iraq in 2004, we started rallying a group of NGOs who could get behind that effort. And the pillars of the Blue Shield movement are the International Council of Museums, the International Council on Archives, the International Federation of Libraries and Archivists, and ICOMOS, the International Council on Monuments and Sites. And so the idea behind it is that you rally those NGOs in your country to come together to form a Blue Shield national committee in each country. Many countries that have Blue Shield committees already had ratified the Hague Convention from day one or many, many years ago. But for the US, our intention with forming the US Committee of the Blue Shield was to seek ratification. And I think we started around to really A lot of people had been working on it for a long time, but as Blue Shield, we really committed ourselves to it back in about 2006. And then, as Dick said, we finally deposited our instrument of ratification with UNESCO in 2009. I think one of the challenges with the way the Blue Shield is set up to deal with Hague Convention issues is that I think a lot of people don't really see the 54 Hague Convention as law of war or international humanitarian law. Because it's administered by UNESCO, they may see it more as a cultural heritage treaty, like the 1970 UNESCO Convention or the World Heritage Convention. And I think that's probably one of the biggest challenges that faces us when people are thinking of the Hague Convention less as law of war and more just about cultural heritage. So that's kind of the background on the Blue Shield.
Wonderful. Thank you very much, Corey. I want to go to Roger because I saw you nodding your head when Corey made that point about how some individuals might view the Hague Convention as more of a cultural heritage convention rather than humanitarian law. Would you like to comment on that at all, Roger?
Yeah. I mean, it's somewhat ironic in that what is known to cultural heritage people as the Hague Convention is just actually the last in a very, very long line of Hague Conventions on the laws of war. It's probably, I don't know, the 18th Hague Convention or something. I think that probably was definitely in the past something of a challenge, although I think now, there's been enough mainstreaming in this regard. I think what also helps is that the rules in the Hague Convention are in large measure, but not completely, paralleled in customary international law, and that at least one or two of them also found their way into the additional protocols of 1977. But certainly I think Corey is right in the past, and this also has been emphasized somewhat by the fact that the International Committee of the Red Cross, although it has a mandate in this regard because these rules find their ways into the Geneva Conventions and protocols, has been somewhat reluctant to take the lead in this area, leaving it to UNESCO. But UNESCO doesn't have much by way of capacity, and UNESCO is looked at by militaries, completely understandably, as a sort of, perhaps potentially wishy-washy cultural organization that doesn't know much about the sharp end of fighting. So the convention has, I think, suffered from falling between two stools, but I think these days it's being taken on board definitely by militaries who now, I think, are beginning really to see it as part and parcel of the laws of war. The real challenge, I think, however, is that not all the rules are directed towards the military. Many of them are civilian oriented, and we have to emphasize those rules just as much as the rules that form part and parcel of the law of war proper.
And that's a perfect segue, Roger, to speaking with our two panelists from the Treasury Department, who focus on those rules related to sanctions. So I'd like to now turn to you, Maria, for discussion about the role that sanctions can play in atrocity prevention and cultural heritage protection.
Thanks, Darren, and thanks to the American Society of International Law for including us in this discussion. Before we offer any comments, I think we have to deliver the standard caveats that, Ari and I are here today in our personal capacities, not our official capacities, and we're not speaking on behalf of the Treasury Department or the U.S. government writ large. We also want to acknowledge that Treasury is just one component in the broader interagency effort across the U.S. government to address issues of atrocity prevention and cultural heritage protection. And especially want to recognize that there are experts in international law and criminal accountability, both across the U.S. government and in civil society and international organizations, including many of the panelists today who spent, devoted years of service and study to these topics. So all that being said, I think it is telling that you invited Treasury to participate in this discussion because so often sanctions are one of the few available tools for accountability against perpetrators of atrocities and cultural destruction. So I think we'll focus our comments today on the role played by OFAC in this global effort in terms of implementation of domestic US sanctions. So I'll just provide an overview of the major types of sanctions that OFAC administers, and then I'll discuss the key legal authorities in domestic law for imposition of those sanctions. So there are two major types of US sanctions, just for people's background. One is so-called country-based sanctions, and those are the trade embargoes against Cuba, Iran, North Korea, and Syria that you may be familiar with. And these sanctions work primarily by prohibiting US persons from engaging in transactions with sanctioned territories. So for example, US individuals and entities are broadly prohibited from exporting most goods and services to Syria unless a license or exemption applies. The second category is so-called list-based sanctions, and those are targeted sanctions that impose asset freezes against sanctioned individuals and entities, essentially by blocking any of their property that comes within US jurisdiction. And those sanctioned individuals and entities are often listed on what's called a list of specially designated nationals and blocked persons, or an SDN list. And so we have sanctions programs that target a really broad range of malicious activity, including terrorism, human rights abuses, corruption, WMD proliferation, narcotics trafficking, et cetera, which I'll let Ari speak to as well. But I think we already have a broad array of tools that the US government can use to sanction people who are involved in these types of activities. Second, from a legal perspective, since this is a legal audience, I did just want to outline sort of the three key legal authorities that we use to impose US sanctions. One is that sanctions can be imposed through an executive order issued by the president under the authority of the International Emergency Economic Powers Act, or IEEPA. The second is that sanctions mandated by UN Security Council resolutions can be imposed through the authority of the UN Participation Act. And then the third way is that sanctions can be imposed through legislation enacted by Congress and signed into law by the president. So just to devote a couple of seconds to each of those, IEEPA is a 1977 law that authorizes the president to impose sanctions to deal with national emergencies declared under the National Emergencies Act. So the way that this typically works is that the president would issue an executive order declaring a national emergency with respect to a particular country or activity, and then impose sanctions against people who meet certain criteria. Another way to impose sanctions is through an executive order that imposes trade restrictions. So there's approximately 30 different national emergencies declared under IEEPA that are the basis of executive orders imposing sanctions. Just one of note here is Executive Order 13350, which was issued in 2004 and prohibits trade in Iraqi cultural property illegally removed from Iraq since 1990. And the second legal authority I mentioned, the UN Participation Act, that authorizes sanctions to implement UN sanctions adopted by the Security Council under Article 41. And specifically, the language of that statute is that provides authority whenever the United States is called upon by the Security Council to apply measures which said council has decided pursuant to Article 41 of said charter are to be employed to give effect to its decisions under said charter. And then finally, Congress sometimes passes legislation stating that it authorizes or directs the president to impose sanctions with respect to particular persons or activities. Just one example of that is the Global Magnitsky Human Rights Accountability Act, which authorizes the president to impose sanctions against foreign persons determined to have engaged in certain gross violations of human rights. And I think with that, I'll turn it over to Ari to speak a little bit about how OFAC has applied its sanctions against these types of activities and actors.
Great, thank you very much, Maria. Ari. So Ari, I think you're muted.
Yes, good morning. Hi, can you hear me?
Yes, we can hear you.
Great, thank you. Thank you so much. And thanks to ASIL for having me and all of us here today. Thanks for the opportunity to participate. I think just to sort of take up where Maria left off, I'm happy to provide a very quick overview of the sanctions targeting process for those who might not already be familiar with that, and talk a little bit about the role that sanctions and other financial tools can generally play in atrocity prevention, which is obviously a very complex problem. To start, it's worth noting that approximately half of OFAC sanctions programs have either human rights or corruption-related designation criteria, which OFAC has used consistently to sanction bad actors around the world that are engaged in a range of illicit and nefarious activities. In addition to the sanctions programs that Maria mentioned, like the Syria and Iraq related authorities, we have counterterrorism and several other important authorities that I'll talk about a little bit more in depth in a minute. But just noting that OFAC administers several sanctions programs that target the activities of bad actors that have had a role in violent conflicts all around the world. Just a few examples of these programs include the Democratic Republic of the Congo, Libya, Mali, and Zimbabwe, among several others. Additionally, we have several global authorities that focus on topics like transnational criminal organizations, counter narcotics, and cyber-related sanctions that have helped us target bad actors in their networks, oftentimes with far-reaching impact. It's not uncommon to find that those who have been targeted by OFAC for a specific kind of activity are actually engaged in a range of other illicit activities. So it's obviously a very complicated problem that we often find very targeted solutions for. Generally, just when determining whether sanctions are the right tool to use in a specific context, we often consider several criteria. For example, can we induce the targeted persons to cease behavior by curtailing their financial activities, even when it doesn't necessarily involve US banks? Can we pressure foreign governments to investigate, prosecute, or seize assets of targeted persons? Can we bring negative public attention to the targets and raise reputational risks for associated third parties? And then finally, can we pressure associated non-designated members of the network, family members or targets, and others? I think in addition to that, from our perspective, an impactful sanctions target would include some or most of the following criteria. There's oftentimes we ask ourselves whether or not the individual or the target belongs to an identifiable network playing a key or significant role in the illicit activity. Does the targeted individual or entity belong to a broader network with ties? And also perhaps an incentive to maintain those ties to the international financial system? Is it an entity or a company that does legitimate business in addition to illicit activities? Is it an individual perhaps that cares about their public perception and could be leveraged against by either the threat or the actual imposition of sanctions? And then lastly, and this goes, I think, a little bit to more of the nitty-gritty of how we actually build sanctions designation cases, do we have multiple credible sources of information and reporting on the network and activities? So I think that's sort of just in very general terms, some of the criteria that we look at. In sort of broad terms, there are a variety of sanctions tools in addition to sanctions designations, particularly in addition to actual designations, which would list the individuals and entities on our specially designated nationals list, and would prohibit them from basically being able to access the US financial system. Treasury engages in a range of different engagements, including with multilateral bodies. Multilateral coordination is very key. Historically, we've been part of the Counter ISIL Finance Group, and also our engagement through the Financial Action Task Force, or the FATF, which is an international policy-making and standard-setting body dedicated to combat money laundering and terrorist financing, has been key in being able to target the finances of ISIL and other terrorist organizations that have engaged in a range of atrocities, as the group knows, and also cultural heritage destruction. So I think, just to wrap up, it's important to note that financial sanctions are just one tool in a whole of government effort to disrupt and deter serious human rights abuses and atrocity crimes. Oftentimes our sanctions do complement other actions by the US government, including visa denials, capacity building programs, or diplomatic efforts. Also, by working in lockstep with our partners in the interagency, State Department, law enforcement, intel community, et cetera, we can maximize our efforts and sequence the use of our authorities in a smart way. So I think that pretty much wraps up my piece, but happy to take any questions or just turn it back over to you.
Okay, thank you very much, Ari. So I'd like to actually build on some of what you discussed. You talked a bit about how sanctions can also be used in a manner that enhances other prevention efforts targeted towards atrocity crimes. And so I'd actually like to now turn to the kind of the other side of the spectrum, right? We've talked a bit about efforts designed around, as Roger framed it, capacity, right? And efforts at prevention and shaping the behavior of our armed forces and prevention efforts targeted at perpetrators. I'd now like to turn to the question of accountability. And so I'll turn to Roger with this question. Could you talk to us a bit about the avenues that exist for bringing perpetrators of these atrocity crimes and of cultural destruction to account?
Sure. There's essentially two legal mechanisms, Darren. The first, and the one on which I won't concentrate so much because in our present context it's less relevant to what's been going on recently, but nonetheless in the past has been very relevant, and that is state responsibility. If a state is held responsible for breaching its obligations under these rules, it will owe an obligation to make full reparation under international law. The chief form in which this has been imposed in the past is in the form of compensation. Now, compensation not just in terms of money, but in the past, there was also the practice of compensation in kind. That is, after the First World War, Germany was forced to hand over books of equal value and equal sort to those that it burnt to the ground in the city of Louvain. There's also been restitution. That is, handing back what has been taken in the cases that have been able to be handed back. So using the mechanisms of state responsibility, reparation in the form of restitution or compensation is an important tool historically. And just to fast forward things, I've mentioned some examples. I'll give you one or two more. So at the end of the First World War, at the end of the Second World War, in the various peace treaties, they made provisions in this regard, but also more recently. So after the invasion of Kuwait by Iraq, the United Nations Compensation Commission, in a particular case, obliged Iraq to make reparation in the form of compensation for the destruction of a collection of priceless and rare Islamic books and artifacts owned by a particular collector in Kuwait. The Eritrea-Ethiopia Claims Commission equally forced Ethiopia, legally compelled Ethiopia to make reparation for the blowing up by Ethiopian forces of something called the Stela of Matara, a giant ancient obelisk effectively in Eritrea. But the mechanism more commonly used, and certainly these days more commonly used, is individual criminal responsibility. That is, the criminal punishment of the individuals actually involved in the activity. These individuals may be in a state's armed forces or even indeed in the government of the state, but equally they may be non-state actors. And international criminal responsibility in the context of non-state actors is a very important tool in an area in which other tools are less available, that is, in the context. So deliberate destruction of cultural heritage is a war crime, both under customary international law and under treaty. In relation to treaties, under the 1999 Second Protocol to the Hague Convention in particular, Chapter 4 has a rich selection of war crimes in that regard. Equally, the theft, plunder of cultural property constitutes a war crime, as it does, of course, with pillage and other forms of seizure of private property more generally. When used in a persecutory fashion to target a particular group, for example, the Yazidi or the Bosnian Muslims, or in the past, the Jewish population of Europe, destruction and indeed plunder of cultural property can also be a crime against humanity. Now, these crimes can be enforced both at the international level and at the national level. And in the past, at Nuremberg, a few of the defendants, amongst their many other charges, were charged with and convicted of the massive destruction of cultural heritage and the massive plunder of cultural heritage in the Soviet Union in Operation Barbarossa. The International Criminal Tribunal for the former Yugoslavia convicted a range of individuals for example, the attack on Dubrovnik, the systematic destruction of mosques across Bosnia, including many priceless examples of Ottoman architecture. And more recently, Al-Mahdi, the defendant, Al-Mahdi, one of the people involved in the destruction of 9 World Heritage sites in Timbuktu in Mali, pleaded guilty and was convicted in the International Criminal Court. Another person currently awaits trial for the same thing. And in the International Criminal Court, it's not just criminal responsibility, but also the imposition of reparations on those responsible. Even if they can't necessarily pay it, reparation may be paid out of the trust fund. The final thing I'd like to emphasize in the criminal context is enforcement at the national level through treaties, through international criminal cooperation, which provide for universal jurisdiction, which provide for obligations of extradition or prosecution. And in this regard, we have to think laterally and realize that, for example, membership of ISIS is membership of an organized criminal group. And so treaties like the United Nations Convention on Transnational Organized Crime are applicable. And indeed, the states parties to this convention have urged and recommended its use in a resolution of the Assembly of States Parties for combating illicit traffic in cultural heritage by such groups, but equally, of course, by other groups, mafias and so on, who always stand to profit from the illicit traffic of goods from war zones. So non-criminal and criminal mechanisms enforceable both internationally and nationally.
Wonderful. Thank you very much, Roger. And finally, I'd like to turn to you, Corey, because we know that in terms of preparing, right, records for either a criminal prosecution or some form of reparation, it's very important to ensure that we have preserved records through appropriate documentation. So Corey, could you talk to us a little bit about the documentation initiatives that you've been involved with?
Sure, thanks. So for those of us in the cultural heritage profession working on disaster response, one of our challenges is when colleagues are impacted by one of these intentional destructions or collateral damage or other criminal activity, we want to be able to hurry and do immediate documentation and salvage to protect the remaining collections. But for instance, in the aftermath of destruction by ISIS in recent times, working in Iraq, for instance, at the Mosul Museum, and also we have a Smithsonian project where we're working to salvage the archaeological site of Nimrud, which was blown up by ISIS. We were cognizant of the fact that before you do that salvage, that we have a responsibility to really particularly document the scene as well as gather any type of criminal evidence. And cultural heritage professionals usually aren't very well prepared to do that kind of thing. So we've been working on a methodology, working with the FBI and others in the US interagency on how to do that kind of activity. And we used the Mosul Museum as a sort of pilot project last year, and we're hoping to develop that further. But just being able to document on the ground what happened there, like a cold case crime scene, we see as a potential for helping with those kinds of criminal prosecutions later on.
Okay, wonderful. Thank you very much, Corey. I see that Dick has a comment. So Dick, I'd be happy for you to make your comment. And then we've got also a few minutes left for questions. So perhaps, Dick, why don't you go ahead and make your comment, and then we'll move to our question from our audience.
Thanks, Darren. I just wanted to quickly mention one other avenue that's important for protection of movable cultural property, which is a prevention and criminalization of looting of movable cultural property. Some states have created comprehensive legislation to prevent illicit trafficking of movable cultural property, and that has been successful in many instances. But the U.S. has a peculiar approach to that, and the U.S. has to pass specific legislation for each conflict that entails negotiation with the country that's been the target of this traffic. And so recently we've passed legislation with regard to Iraq, Afghanistan, and Syria to prevent looting of that property. But we would be better served by more comprehensive legislation like that in Canada and other states that would prevent it in all armed conflict, rather than having to go through the process for each individual conflict.
Wonderful. Thank you, Dick, for that reflection on the U.S. approach, and also a recommendation on an improvement in our legislative approach to looting. We have one question from the audience, and so I'm going to open this up to the entire panel, whoever would like to answer it. So the question is, given that many of these atrocities are perpetrated by non-state actors, apart from any international criminal law sanctions, could there be any civil remedies along the lines of state responsibility? Roger, you already spoke about this a bit, but if anyone else would like to comment on the question of civil remedies. All right, Roger.
The problem with non-state actors is that as far as international law is concerned, and this is a curious anomaly, they owe obligations under the laws of war, but it's not actually clear that they bear responsibility for breaching them. The reasoning is as follows. If they win the war, they become the government of a state, and you have retroactive questions of state responsibility under Article 10 of the Articles. If they lose, they get disbanded, and there's nothing to seek civil remedy from. The best we can do, as currently happens, is pursuant to a prosecution either in the International Criminal Court or in some states, you can have a derivative form of civil responsibility, an obligation to make reparation for a criminal act. Now, to us common lawyers in Australia, where I'm from, the US, the UK, civil and criminal don't mix. They're different things. You've got tort, you've got crime. But in the International Criminal Court and in many civil law systems, you can have a criminal prosecution followed by an obligation to make reparation. Equally, of course, you could seek through simply the law of tort and actions for various forms of conversion, provided the law of conflicts is in your favor, simply to seek to get the stuff back that way. Finding them is the difficulty.
Okay, and on that note, I want to thank all of the panelists for their wonderful insights into the many questions, the myriad questions related to how we best protect cultural heritage and property under international law. And we thank all of you viewers for participating.